Good afternoon and a very big welcome to our webinar. And for those of you that are new to our webinars, we are, of course, Jones Chase Employment Lawyers. We act for a number of companies from PLCs all the way through to startups. And we also act for some fantastic individuals as well. And we're proud to say that we have a very high success rate for looking after those that we represent. In terms of the format for the webinar, if you want to ask questions, please do so using the Q&A box. If you want to do so anonymously, please hit the anonymous button. We are recording the webinar as well, so please bear that in mind if you're asking questions and you want to do it anonymously. And I should also emphasise that the points we're covering in today's webinar are not formal legal advice. If you need any help, please drop us a line. And as a quick reminder, the information that we're covering today is accurate as of 1 p.m. on the 27th of February. Okay, so we've got a number of topics to go through today. We've got Susanna, who's one of the firm's partners, is going to speak to you about Intro to Feelings Awards. We've also got Shona, who's going to speak to you about a favorite employment law topic, which is TUPE. And first up, we've got Tanya, who's one of our trainee solicitors on secondment from our friends at Bolt Burden Kemp, who is going to speak to you about the forthcoming changes to employment law in 2025. So over to you, Tanya.
Thank you, Dean. So there are quite a few employment law changes to be keeping an eye on this year, and I will be focusing on 5 key changes. Starting off with arguably the biggest change is the Labour government's Employment Rights Bill, which was introduced on the 10th of October 2024 and is expected to receive royal assent in 2025. It is worth noting that receiving royal assent does not mean that that is the effective date each part of the bill will come into effect. Turning now to the key changes in the bill. Unfair dismissal will be a day one right for employees, whereas at present employees only have the right to claim for unfair dismissal where they have been employed for 2 years. This reform is not expected to come into effect until autumn 2026. There is also a proposal by the government of an initial period of employment, which will essentially act as a probationary period where dismissals that occur during this time will be subject to a lighter touch regime. The specifics of what this lighter touch regime will be still need to be ironed out through consultation, but suggestions have been made that this would include a meeting with the employee where they have the right to be accompanied to discuss concerns prior to dismissal. According to the government-published Next Steps policy paper, this initial period of employment is expected to be 9 months. So essentially, this would create a day one right to claim unfair dismissal with a 2-tier process. First, a lighter touch regime for those employees dismissed from day 1 to 9 months employment, and a more robust process post 9 months employment. The bill is also expected to extend the current right to bereavement leave. The current law is that parents of a child who dies are entitled to 2 weeks paid bereavement leave, and the Employment Rights Bill is looking to extend the list of those eligible. Although any employer policy can provide a more beneficial period of leave and/or breadth of eligibility. The bill is also proposing to amend the threshold for collective redundancy. The threshold for triggering collective redundancy consultation notification is currently where an employer proposes to dismiss 20 or more employees as redundant at a single establishment within a 90-day period. The bill is looking to remove the requirement that these 20 dismissals be done at one establishment. The impact of this is that multi-site employers will now have to collectively consult where they're proposing to dismiss across different sites, and so they would need to be keeping accurate record of all site proposed dismissals. This could also have an impact on remote working or home working, as each location can arguably be one establishment, whereas in future that may not be the case. Overall, the overarching impact of the Employment Rights Bill will be to strengthen the rights of the employee. The second key change I would like to discuss is the Fire and Rehire Code of Practice. By way of background, the controversial practice of fire and rehire occurs where an employer wishes to amend the terms of their employee's contract of employment to be less favorable to the employee. For example, by reducing pay, changing shift patterns, or reducing holiday allowances. If an employee is unwilling to consent to this variation to their employment contract, an employer can terminate their employment and offer to rehire them on a less favorable employment contract. Hence the phrase fire and rehire. If the employee refuses the offer of rehire, they're effectively dismissed. Currently, this is not illegal to do, but there must be a sound business reason for firing and rehiring, and it should only be done as a method of last resort. Notice must be given as payment in lieu or worked or garden leave, depending on contractual rights. If there was no process followed, those employees with more than 2 years service can claim unfair dismissal. Unsurprisingly, the practice of fire and rehire has received negative media attention, and as such, the government introduced a fire and rehire code of practice which came into force on the 18th of July 2024. The code doesn't outlaw the practice, but introduces guidelines to promote fairness and transparency. For example, the code states that information should be provided as early as reasonably possible, and as much information as reasonably possible should be provided to the employee to enable meaningful consultation. Now, the reason I'm including this topic in a talk about employment law in 2025 is because from the 20th of January 2025 onwards, tribunals have the power to increase or reduce any monetary award they make to an employee fired in this way by up to 25% for unreasonable failure to comply with the code. A third key change to be aware of in 2025 is the Neonatal Care Leave and Pay Act, which received royal assent in May 2023 and is expected to come into force in April 2025. It will introduce statutory neonatal leave and pay for up to 12 weeks for parents of babies requiring neonatal care, and this leave must be taken within 68 weeks of birth. This will be a day one right for any employee. Moving now to the fourth key change is the Draft Equality, Race and Disability Bill, which was announced in the King's Speech in 2024. It's expected to be the subject of significant consultation, and so it will likely be a lot slower to progress than the Employment Rights Bill. Whilst there's limited information on the details of this bill at present, we know its overarching aim is to ensure equal pay for ethnic minorities and disabled people. One of the ways it plans to do this is to introduce mandatory ethnicity and disability pay reporting for employers with 250 or more employees, and this is likely to be along similar lines to the current gender pay gap reporting. Finally, for 2025, I will cover the case of Higgs and Farmers School, as the Court of Appeal handed down its judgment on the 12th of February 2025. This case concerned a Christian school administrator and work experience manager who was dismissed following a number of Facebook posts in which she criticized the way gender and relationships were being taught in school. The school's head teacher received an email from a parent which complained about a post which was a reposting of another post, where the teacher added, "Please read this, they are brainwashing our children," and included a petition to sign. Other posts included reposting of views which refer to gender fluidity as a perverted vision, and that, quote-unquote, the LGBT crowd were destroying the minds of children and promoting mental illness. Following her dismissal, the teacher brought a claim for direct discrimination and harassment in both cases on the ground of religion or belief. The Court of Appeal very recently handed down judgment in the school teacher's favor, confirming that gender-critical beliefs and the manifestation of those beliefs are protected by the Equality Act 2010. But if expression of those beliefs is objectively objectionable, then dismissal will be lawful if it was a proportionate response. The court said that the teacher's beliefs had not impacted her behavior at work and were not expressed at work, so the school's response to dismiss her was not proportionate to the perceived reputational risk. Now, this is a very fact-sensitive area of case law, and determining factors the court referenced in coming to its decision included the fact that the teacher was a long-serving employee, there was no complaints about her actual work, her language was not grossly offensive, and there was no evidence of actual reputational damage. So what are the key takeaways from this case? Employers should be wary of the increased risk in dismissing in cases of personal belief expression. They should also be wary of the limits courts have in accepting arguments of reputational risk. Thank you very much for listening. I will now hand back over to Dean.
Okay, thanks so much, Tanya. That was great. And as everybody will find out from your section, there's a load of legislative developments basically forthcoming, and also thank you for the case update as well on that really important decision. And yeah, we as a firm, we will constantly keep people updated as well in terms of as and when the new law starts coming out or there's more developments or results of consultation, we will be sending bulletins and there'll be further information on our website as well. So that's great. Thank you so much, Tanya. I'll just move on quickly to Susanna, who's going to discuss Injury to Feelings Awards.
Thanks, Dean. So I have decided on this topic because I think it's always useful for us to have a reminder about how we're dealing with compensation when we're looking at awards, in particular relating to discrimination. And I am aware that the employment judges and lay members have recently received some extensive training on assessing injury to feeling awards. And interestingly, we've had these two recent EAT decisions, the Shakil versus Samsons Limited, which is 2024 decision, and the Stobbart Limited and Graham EAT decision, which is a 2025 decision. Both of these were relating to pregnancy and maternity discrimination, where injury to feeling awards were considered on appeal by the EAT, and we've had some useful, I think, guidance that's come out of those. So one was in respect of the injury to feeling award being too low, and the other was in respect of the award being too high. And so what I want to do is to focus on what it is that the tribunal need to be looking at when they are considering making an award for injury to feeling, and just to remind us of where we need to be looking at it if we are defending such claims. So a tribunal's focus should be on the effect of the injury rather than the descriptions in the Vento guidelines and the bandings that we have. The tribunal is actually compensating for the injury suffered by the individual, not the manner of the discrimination that they may have suffered. And awards for injury to feeling in the same scenario, so if you had two individuals with exactly the same discriminatory act, could end up having completely different awards of compensation for injury to feeling made, because there will be different impacts potentially that the discrimination has had on them. So just bear that in mind. It's not an exact science, and it is very much about how the individual evidences the effect of the injury on them. So we all know about the Vento bans, but just to recap, they are currently at the lower end, they are 1,200 to 11,700, and these are where the cases aren't serious and could be isolated or one-off occurrences. But please don't think that just because it is an isolated offence, that means that the award would always be in that lower band. The middle band is currently 11,700 to 35,200, and this is for serious cases which do not merit, however, an award in the higher banding, which is currently 35,200, rising to 58,700. And this is really for awards where there is evidence of a lengthy campaign of discrimination and harassment. And in very, very exceptional circumstances, an award could exceed 58,700, but they do appear to be exceptional. Those bandings are reviewed and updated annually in line with inflation, and so from the 6th of April we will see that those bandings increase. So the tribunal's role in assessing an injury to feeling award is to carry out an analysis of the claimant's feelings as a result of the discrimination they've suffered and to monetize this. The production of medical evidence is not necessary, but it is likely to be helpful. And the tribunal will not consider making an award for personal injury, which is something that they can also do, if there is no medical expert evidence, and it's unlikely that just a doctor's note is going to be enough. I'm concentrating, however, today on injury to feeling. Importantly, remember, it's not a punitive award, and the tribunal must not allow their feelings of indignation or disapproval of the employer's conduct to inflate an award or colour their view of the injury that has actually suffered by the claimant. A tribunal, when they're applying the Vento guidelines, generally must do the following. They need to identify the discriminatory treatment for which an award of injury to feeling is to be made. They'll hear the evidence from the claimant about any injury to feeling caused by the discriminatory treatment. They need to make findings of fact about the injury to feeling suffered. They need to identify the relevant guidelines applicable to that award, and then state which band the injury to feeling award falls within, and give an explanation as why the injury is falling within that band, and also why the specific award and the amount is being made. And that is effectively what the two cases have looked at in terms of where they've appealed. There is very much a burden on the claimant to show that his or her feelings have been injured, and to what extent. If there is no evidence of injury to an injury, then no award can be made. If evidence is limited, there is an accepted position that there will be some injury as a result of the discrimination occurring, and therefore the tribunal will in all likelihood infer some level of injury. And what's been helpful is that the Eddie Stobbart and Graham case has elaborated on both of these points for us. So in the Eddie Stobbart and Graham case, the company appealed to the EAT, arguing that an award of £10,000 for injury to feeling was excessive, as to be perverse. So they were effectively saying that a reasonable tribunal, no other reasonable tribunal would have made that decision. They were arguing that the failure to deal with the grievance was a one-off isolated incident, and therefore the award of £10,000 was disproportionate. In this case, it was claimed that the company had failed to take adequate steps to deal with a grievance that the claimant had twice emailed to it, which had been blocked by its firewall. So she was claiming, so in this case, she'd been identified, she was pregnant, she'd been identified as at risk of redundancy because the company were choosing to stop having planners in its Scottish office. There were 4 other positions that they created, and Miss Graham said that she should have been automatically put into one of those roles by virtue of the protection that she was arguing suitable alternative employment, and therefore she should have been protected above anybody else who was at risk. They didn't agree with her. She raised a grievance, and as I said, she raised it twice, but it was blocked by the firewall. Now, at tribunal, they didn't find that the position she was saying should have been given to her was suitable, and so they didn't uphold that complaint. But they did find that she had that the company had not treated dealing with the grievances properly, and she had suffered detriment as a result of that. So when it came to her arguing about injury to feeling, she put the evidence she presented was that she had been shocked and upset. She provided no evidence of any impact on her personal life or quality of life. And accordingly, the tribunal, the EAT, said that based on the evidence that she had put forward and focusing on the effect and impact of on her for injury to feeling, that the amount that should have been paid to her was £2,000 plus interest. They gave us the helpful guidance, though, on what evidence claimants should provide, which would assist the tribunal when making an award for injury to feeling. So really important for you to describe, for the claimant to describe their injury, to explain the duration and the consequence of the injury for them, to effectively provide a before, current and future impact for them, and also the impact on their personal life and quality of life. And clearly in that situation, a third party evidence, probably from a family member, is likely to be compelling. The EAT also gave us some useful guidance on the relationship between the manner of the discrimination and the likely level of injury. And so they have given guidance that overt discrimination is more likely to cause distress and humiliation. Discrimination played out in front of colleagues or for others to see may well cause also greater harm. Disciplinary threats may provide a basis for inferring more serious injury to feelings, and exclusion, which causes isolation, can also indicate a more serious injury. So if any of those markers are hit, then actually the impact will be greater for an award of injury to feeling. By contrast, in the Shakil and Samsons Limited case, the EAT found that the tribunal's analysis of injury to feeling, when looking at those Vento guidelines that I talked about in terms of what they have to do, was wholly inadequate. This was because it had failed to do most of those things and had provided no explanation regarding why the Employment Tribunal had placed the injury to feeling award in the middle of the lower band. So Ms. Shakil had been awarded in this case £5,000 for injury to feeling. Her claim arose as a result of treatment she suffered when she called in sick to tell her employer that she was feeling unwell and was suffering from morning sickness. The day after she made that call, her work was reduced to 2 days a week. And then 6 months later, she was informed that she had been provisionally selected for redundancy and she was dismissed shortly thereafter. So she brought a claim. The tribunal found that the reason for dismissal was her pregnancy and not redundancy, but they only awarded, in those circumstances, the £5,000. Now, that, as I said, they weren't happy with that. They felt that they had not applied the process properly at all. And so they remitted it back to a brand new tribunal to assess, because the tribunal had acted in a way in which they had, which was wholly inadequate. So I guess the take homes for you and me and all of us is that the tribunal are going to focus on definitely the vulnerability of the claimant. They will look to assess the degree of the hurt, as well as the distress and upset caused. But it's very much going to be based on evidence that they hear from the claimant. And so that is a keynote for us to all remember when we're acting, if we're acting for individuals, but also when we're defending claims, and in particular when you're looking at witness statements and seeing how they're describing the injury to feeling, so that we can look at what our real risk is in relation to potential awards. I'm happy to answer any questions at the end, perhaps, if anyone wants to raise anything.
Thank you, Suzanne. Oh, I was just going to ask about the points to be put on an ET1. Do you think it's worth the claimant in the ET1, when they're claiming injury to feelings, to put in the impact on my personal life has been this, and the impact on my quality of life has been that, and actually say something in the ET1 so that it's then a point that can be answered in the ET3, or could be raised in the ET3. Maybe I can't see any impact on the quality of life or personal life. I've looked online, I've looked at all their social media, and it looks like they're having a great time.
I think you could. I mean, what my experience is that the tribunals are now making directions that the claimants must provide impact statements anyway, which I think is helpful, certainly for us when we're defending. I mean, it's not something that they used to do, but I think they're doing it now more regularly. And I think where we're acting for respondents, we would definitely want to probably be asking for that, because we might want to be then finding evidence to counteract it. The only thing I would say is that from my really looking into this, is that it does seem to be very much based upon what the claimant is saying. And so I'm not sure how far the respondent is really going to get.
Well, I agree. That's why I wonder, the social media is all I can think of as obtaining evidence from another source, or maybe you would hire a detective or someone to go and look to see that the life isn't as awful as they're suggesting it is in that impact statement. And quite a lot of preliminary hearings are 9 months, maybe a year after the claim has been brought. And if you're waiting till then for that impact statement, settlement discussions may take place in which the solicitor is, well, whether they're over-egging the impact on their client or not, or the individual themselves is overstating it.
I would also still say, though,
the argument.
I would still say, though, and I'm constantly surprised by this, is that I don't find that the tribunals are particularly generous in their awards of injury to feeling. I've always been quite shocked at how low they often are, even in circumstances where you would have said the discriminatory behaviour was pretty poor. But that is evidence, isn't it? It's the whole thing, which is it isn't based on the conduct of the employer in relation to the discrimination. It's how the employee felt or the impact it had on them. So I think, I mean, the biggest risk for employers, I have to say, is medical evidence.
Yeah, and just on that, I was going to say as well is that discrimination claims can be brought during employment. Often they're brought at the end of employment, but of course they can be brought during employment as well. And if somebody is, I've just thought of this, I'm just saying it out loud, maybe maybe a bad idea, who knows? But if the person is still employed, then there may be the employer may have the contractual right to require them to see a doctor potentially. If the employee is saying I'm very unwell, and it's in the tribunal case as well. But obviously that's much more difficult when employment is ceased, of course. So it's just one thing to think about. If you do have we always recommend employers having a contractual right to require the employee to undergo a medical assessment as well. Maybe that can be used in the right way, maybe not, but something else.
Although just to also say that even though you might have contractual, that might be an express clause in the contract, you actually cannot force somebody to attend a medical appointment. But if that is what the employee chooses to do, then you are entitled to form a decision based on the information that you have. So that can be helpful to an employer.
Mm-hmm.
But often that medical appointment, if it's with OH just writes down what the individual tells them. So the individual is saying, I'm not sleeping, I'm not this, I'm not that. And we had a case quite a few years ago where the individual was, their impact statement said that they were living on a bowl of porridge a day, and the individual said that their life had just been completely ruined by what had happened within the employment context, and couldn't stomach anything other than a bowl of porridge. And when we were chatting to the HR team and trying to find out evidence about the individual's life, they said that he was a keen runner. And so we looked up online. He had his running stats online. He was participating in Ironman runs, etc. And so we sent this to his lawyer to say, good grief, you've sent us this thing about a bowl of porridge. And at the tribunal, the judge also picked up on the point. The solicitor was having none of it and said we were at went to tribunal, and the judge picked up and determined that there was no injury to feelings, and this individual's claim fell on the basis that he couldn't possibly be doing the athletic things that we'd found out based on a bowl of porridge a day.
Interesting.
Thanks for that. And we just had a a question, and this is from Carl. Hi, Carl. And so Carl's saying, for the benefit of those watching the recording, a claimant's impact statement should contain a statement of truth. And do we think that it could be strategically smart to ask the claimant to provide an impact statement as soon as possible? And if evidence from social media or otherwise shows the impact is not so bad as stated, to point out that the statement of truth, to point out that the disconnect between that and the statement of truth then goes to credibility. So I would say yes to that.
I would too, yeah. I asked for the impact statement in the first preliminary hearing as part of one of the directions to be given.
Yeah, but again, asking it before that, the other side is going to say, we don't have to do this at this point in time. It's a preliminary hearing point. And it's that delay between the claim and the preliminary hearing that then is the problem. I think if you ask before that preliminary hearing, you're not likely to get it.
No.
Just conscious of time as well, and definitely get to Shona section.
Well, can I just ask one more question, just about the medical evidence? Is there a position to say, if there is medical evidence, can we have a joint medical appointment? Because it's as much in the respondent's interest to get this information correctly as it is in the claimant's interests. And so at that preliminary hearing, if there is going to be medical evidence, that you would say, we would like this to be a joint instruction and a joint information.
I think so, yeah. I mean, that's my view as well, is because you can often get that for if there's a question of whether a person's disabled or not. You can get an order direction from the tribunal that a joint expert is appointed. Susanna, do you have any thoughts on this as well?
Yeah, I mean, I have to be honest with you, I don't think that's happening enough, actually. I just don't see that happening. And often I think it's because the burden of the cost falls to the respondent quite frequently. So I think there's an issue. That's the problem with the joint, because often the claimant will say, no, I can produce my medical evidence, i.e. my GP records, etc. And then it's the respondent. And then we get into this whole problem again, don't we? Which is I think the quality of medical evidence that might be beneficial to employers is low, if I'm honest with you, by virtue of what you were saying, which is they just take what the claimant says and regurgitate it.
That's great. Anything else on this topic? No further questions at the moment. Of course, there will be time for questions at the end as well. So if there's anything you'd like to ask, please use the Q&A box. And if you want to do that anonymously, please hit the anonymous button. Thanks so much, Susanna. That was really helpful. It's really good to understand what tribunals will look at when dealing with the tricky issue of injury to feelings awards, which, as you've said, is inherently driven by subjective claimant evidence, which can be hard to rebut. So that was super helpful. Thank you. And just moving on to the final section for the day prior to any questions, which Shona's confessed to being her favourite employment law topic, the transfer of undertakings, protection and employment regulations known as TUPE. So over to you, Shona.
It's probably the saddest confession ever that this is my favourite, but
I think it's interesting too, by the way. So
okay. Oh, well, I won't ask what that interesting is. Interesting good, interesting bad, or whatever. I'll just. Or you think it's interesting? It's an interesting topic.
Yeah.
Okay. Sorry, I
Absolutely.
thought you were saying the choice was interesting.
No.
My misunderstanding.
It's a phenomenally interesting, deep, and complex topic. So over to you.
It is. So. In 1981, the law was created, the transfer of undertakings, as Dean has referred to, its full title, and which is commonly called TUPE. And in 1981, it was introduced because there were quite a few events where a business was having problems. It would close down. It would get rid of all of its employees. Bless you. I don't know if you heard that sneeze in the background. Anyway, it would get rid of all its employees, and it would set up the next day and recruit new people or take the same people back. And this was becoming such a problem that legislation was passed to say, if there is a business sent from closed and goes across to another business, there is an automatic transfer of those employees to the new business. and those employees will retain continuity of employment and their terms and conditions remain the same, and it's as if they had their employment commenced by the new employer. So that all related to business transfers, where there's a sale of a business or a closure of a business and a new business opens, or a move to a new business. And that was in 1981. And then in 1997, the world moves on, the way we do business moves on, and added to that transfer of a business was a new concept of a service provision change, which is where you would have maybe a canteen or a cleaning service, and you use a group of people to perform that activity, and you decide that you're going to outsource that, or you're going to have a service provider provide it to you instead of you doing it yourself. And on the change of that activity from one service provider to another, and you yourself could be the service provider, that was determined to be also caught by the transfer regulations. And so we now have two types of transfer. One is a business transfer, sale and moving of a business, and the second is a service provision change, this type of activity that you might have done in-house, as I said, or you had a contractor do it, and it then moves to another. The employees automatically move from one employer to another, and their continuity of employment is maintained. And the reason that we've had to have that law is because the law on the change of an entity that would employ you means that there's an end of a contract and the start of a new one. And that is an event of termination and dismissal. And in order to avoid that termination and dismissal, this law provided that continuity of employment. And the regulations were updated in 2006, and then they were updated again in 2014. And one of the reasons I wanted to talk about it today is because, and the topic, I think, in the invitation was called, Should I Stay or Should I Go? In the middle of all this shenanigans between moving business to business, service provision change and activity from one to another, you have a group of employees, or sometimes only one employee, that's there totally beholden to one employer that is changing their service provider or selling their business to another employer who is possibly the new service provider or the purchaser of the business. And the employee is piggy in the middle, not knowing where it stands as an employee and what its rights are, and should it stay, or can it even stay with its current employer who is either selling its business or changing its service provider for a service activity, or must it go to the new business owner or the new service provider and automatically transfer? And then the employee is in quite a difficult situation as to where it can choose to go or not go. And one of the reasons for the difficulty of that position is because the two parties, the seller, the buyer, the new service provider and the old service provider, they often decide between themselves whether there is a transfer or there isn't a transfer. And many of you may be involved in correspondence with the other side being the potential new contractor or the potential business buyer, where they're saying it's not a transfer, you're saying it is a transfer, both parties are saying it's not a transfer, but it could be a transfer. And the employee remains this piggy in the middle. Am I staying? Am I going? Is the law automatically transferring me? Is it not automatically transferring me? What does the new employer say? Usually saying it's not a transfer, and the current employer is saying it is. And it's to describe the position that the employee can take in this set of circumstances, and what an employer can do, either the current employer, the transferor, or the new employer, the transferee. So the legislation provides that an employee can object to transfer and say to his current employer, I know you're selling this business. I know you're changing a business, the service provider, but I don't want to go. And that is treated as a resignation under TUPE. And Regulation 4.7 in TUPE says that objection to transfer to the employer that you don't want to go is taken as their choice of resignation, and so there is no dismissal. But if that employee is saying, I don't want to go because actually I don't like what the new employer, the person buying the business or the new contractor is offering in terms of my employment situation, that could be the reason why the employee doesn't want to go. It may not be just a personal choice, it's they don't like the arrangement that's being offered by the potentially new employer, or that potentially new employer is saying, this is not a TUPE transfer, and therefore they're not our employee anyway, nothing to do with us, and therefore you sort it out, Mr. Seller, or the original service provider. So in those circumstances, an employee, if they haven't objected to transfer just voluntarily of their own volition, but they're saying no to the transfer because of something that the transferee is doing, then that employee will automatically transfer to the transferee. And if then they don't like what the new employer is doing, if they then leave, is that a dismissal by the transferee, or is it a dismissal by the transferor? So that's one scenario. The employee may leave before the transfer and decide, I'm not going then. And that again is that a dismissal by the transferor, the current employer, or the new employer, deemed employer, because they haven't actually taken them on? Again, it becomes very, very difficult for the employee to know where they stand. And the law will decide that after the event, when the claim is brought, because ultimately whether TUPE applies or not is a matter for a judge to decide. And the two parties can put all their legal arguments to each other and still remain disagreeable about whether TUPE is applied or not. But it is the judge at the end of the day. And the employee will be the person waiting to hear who is liable for the termination of my employment. And there will be a deep pocket on either side, an employer that they've left or an employer that they've joined. But somebody is liable for this employee not having a job on the same terms and conditions that they enjoyed before, and with a contract of employment where there's been continuity of that employment. So TUPE has thought of that from the basis that Regulation 4.9, if there is a substantial change and a material detriment to the employee, and they're dismissed by the employer, so a substantial change because of the TUPE transfer being suggested, and that is a material detriment to the employee, then the employer will be liable for the dismissal of that employee. And the employer in that set of circumstances is the transferor, the original company, the original service provider, and that's Regulation 4.9. And then Regulation 4.11 refers to the employee going across to the transferee and the employee thinking, I don't like this, I'm going to treat myself as constructively dismissed because of the change in my employment circumstances. And Regulation 4.11 refers to the fact that that constructive dismissal, if linked to a TUPE transfer, is automatically unfair, again, for the employee. And so if I were an employer in these circumstances where I'm selling my business, or I've got a commercial contract that I believe is a TUPE transfer to another contractor, but that other contractor does not believe it's a TUPE transfer, I could be left with employees who are not objecting to transfer, and therefore who I am saying will automatically go to the new contractor, but the new contractor is not recognising them as an employee. Am I left with a dismissal obligation of those employees if they have not objected to transfer. And that employer has to decide, do I take the risk of thinking, I genuinely believe TUPE applies, and therefore I believe that the obligation will pass to the transferee, the new employer. And on that basis, I will take that risk. I will tell all my employees, you are now employed by that new company. And if they're not, that the dismissal is by that new company. When I'm advising employers in that situation, one of the options is to say, unless you are absolutely guaranteed in your thought that TUPE applies, you could now think commercially of redeploying these individuals within your own organisation in a new role so that you're not relying on them automatically transferring and being dismissed by the transferee and the liability moving to the transferee. You're commercially taking a pragmatic approach, which is we will carry on arguing TUPE applies, but in the meantime, see if you can redeploy these individuals elsewhere within your business. Otherwise, they could end up with you could end up with the liability for their dismissal. And with the transferee side, whoever is advising the transferee, you would hope would also say, let's be pragmatic about this. If you have other work that these individuals could do and you're not totally sure that TUPE applies, and ultimately that's the judge's decision, thinking about where you could place them to deploy them if they transferred and the transferor keeps alleging they've gone to you. That again is a pragmatic way to treat those potential employees coming into your employment. Now, there's a case prior to, it was decided in December 2024, which addressed this in a sort of way. It's a bus driver who worked for many years within the London Bus Company. He lived 15 minutes away from where he worked, the depot where he drove his bus from, and his bus route. And he didn't drive, didn't have a car, and he walked to work. He did drive. He didn't have a car to drive in. He did drive because he's a bus driver. Anyway, he did drive. Didn't have a car. They didn't drive to work. He walked to work. And this bus company was selling to Abellio. And that was going to change his arrangements so that he would then have an hour to get to work. He wouldn't have a set route. And he didn't want to take on that role within Abellio. He also didn't want to stay at the bus company that he was currently employed with, that he was 15 minutes walk away, because they were changing the bus arrangements and their bus drivers' terms and conditions to go from a set 9 hours to a set 10 hours for their route journeys. And so he didn't want to stay either. And so he was objecting to what the bus company, his current employer, were doing to his terms and conditions, but he also was objecting to what he would be transferred into if there was a transfer of undertaking of his job. And he was in between, should I stay or should I go? He didn't want to stay, he didn't want to go. In fact, he wanted to be made redundant. And the bus company had a job for 10 hours, Abellio had a job that was an hour away. So on the face of it, it looked as if he had the potential for 2 alternative jobs, but actually he didn't want to either, and he wasn't keeping his same terms and conditions. So he said, I don't want to work that 10 hours, but I don't want to work an hour away. And the 2 commercial organisations had to fight out in front of the Employment Tribunal and then the Employment Appeal Tribunal as to who was the employer who was responsible for ultimately this individual being dismissed. And what happened practically in the meantime on the TUPE transfer date, the employee went off sick, and the bus company that originally employed him sent the fit notes to Abellio and said, he's your employee now. Here are the fit notes for him. And the Employment Tribunal decided that the company that was liable was the bus company that originally employed the individual bus driver, not Abellio, that he had not transferred and that he had objected to going. And it was an effective objection based upon the substantial change that the bus company was making to his employment contract, which was to change his shift from a 9-hour to a 10-hour shift. And that was the reason behind the termination of his employment. And despite the fact the bus company thinking he had gone to Abellio, he had not. He had remained with the bus company. So the sort of takeaway from that case is, if that bus company, and understanding that this bus driver didn't want to work the 10-hour shift and wanted to remain on the 9, and the 10 was only being offered because it was linked to the TUPE transfer and the employee didn't want to go. If the bus company had said, okay, we will keep him on that 9 hours and he's his 15-minute walk from work and he remains on the 9 hours, he would not be dismissed. He would remain with the bus company. He would have continued with that employment. There would be no dismissal. And if the employee had left, he wouldn't have been able to argue there was a substantial change to my employment terms, and he wouldn't have been able to argue that it was a material detriment to me. And therefore, there would have not have been the case, successful claim in the first place. And so when you're in a TUPE transfer, I suppose the main point to have in mind is, it's all very well legally arguing to the other side, I think it is TUPE, and then you get back, I think it isn't TUPE, etc. I do think that the main way to deal with TUPE circumstances, if there isn't a consensus that TUPE applies, is to think about redeployment on not substantially different circumstances to the current employment contract, and nothing that's a material detriment to the individual, so that there is a job found for them somewhere. In a recent case that we worked on, there was quite a lot of argument between the two sides about whether TUPE applied or didn't apply. And then eventually there was so much argument that we got to a stage where we wrote and said, look, there are 7 people. We could probably employ 3 of them somewhere. If you could employ 4, everybody's got a job on the same terms and conditions. Isn't that better? And this is what has turned out to be the better pragmatic commercial approach, rather than the more legalistic, the law says this, no, the law says this, etc. So the reason I wanted to cover the topic today is actually to suggest that the law is one thing and it's helpful and it can be helpful in protecting jobs, but there can be a good commercial outcome to circumstances if at somewhere along the line the two parties, the two employers in this instance, put their heads together to say, we could sort this without there being any claim against either of us, because the only person that wins is probably the lawyers. So, yes. Anyway, that's sort of a long-winded way to say that lawyers are always the winners. It's probably... Thank you. You're on mute. You're on mute.
First one of 2025, stuck on mute. I was just saying thank you for explaining a very complex topic so well, and also for offering the pragmatic guidance approach as well, because I think, exactly as you said, all too often TUPE cases become pretty horrific legal battles, going all the way up to the Employment Appeal Tribunal, Court of Appeal, or even further, taking many, many years to get there. And often when you're dealing with outsourcing, you've got two competing service providers who often don't like each other very much, and they will not, there's no pragmatic, well, not, I'll say no, but all too often the parties become embroiled in the legal aspects of it. So it's very refreshing to hear you suggesting commercial and pragmatic approach. Thanks for that. Just conscious of time, we've got a comment from Carl, and in the question box, there's no other questions at the moment, so we'll probably finish slightly early. And Carl said that the terms of any contractual arrangements between the transferor and transferee or client selecting a new service provider to replace the previous service provider It's crucial to identify the allocation of risk and financial liability between the parties. Some incumbent service providers who know they are losing a contract might try to staff dump, which is correct, to place employees in the organised grouping of persons before a transfer date in order to transfer those employees and try to avoid a costly redundancy bill. Yep, that's absolutely correct. Thanks for the input, Carl.
I suppose, though, with a very commercial contract, that staff dumping, the client is never, that's not a happy client if that's going to be the case. So you end up within the actual commercial agreement with the client where there's a thing that you can't move the staff around 6 months before, etc. Yep. So these are all commercial clauses that you can put in with that client.
Exactly, and a well-drafted sort of business purchase arrangement, or even an outsourcing contract can have provisions in there, as you say, to protect from sort of staff dumping, as we call it, or also poison pill clauses as well, where the outgoing employer deliberately changes the terms and conditions of staff to make it much more expensive and difficult for the incoming service provider. So you can, if you're a transferee, you can protect yourself from that as well. Great, there's no further questions, so I'd like to thank everybody for participating in the webinar, particularly Tanya. This is her first webinar, well done. And as a quick reminder, the information we've covered today is accurate as of the 27th of February. We will be sending out a lot of bulletins this year. There's an awful lot of employment law to come through. And if you haven't subscribed already and you found this webinar via LinkedIn, drop us a line at info@jonschase.com and we get you hooked up to our sort of bi-monthly bulletins. And that's it for me. And unless there's any other comments from the rest of the team, just want to say thank you for everybody for attending, and we'll see you soon.
Dean, I would just like to thank you and Susanna as partners along the way for the last 6 years. I've so enjoyed working with you, so thank you very, very much. And Tanya, as the last trainee that I have worked with, thank you very, very much. You've been really, really helpful during your period of traineeship, so thank you. And just the Jones Chase team, they are a great team. I've had a really wonderful time, and all the clients, Jones Chase would be nothing without our clients, because that's what we do. We are a service company, so they're great clients. We've had lots of unusual and interesting cases, and long may that continue. So thank you very, very much.
Thank you, Shona.
Exactly. Yeah, thanks so much, Shona. And we've got a comment from Natasha, which echoes all of our sentiments as well, and basically saying thank you so much. You'll be missed, Shona, from all at CLS. So thanks once again. It's been incredible working with you. And we will see everybody on the next webinar. And thanks once again for attending. Have a good afternoon all. Take care and bye-bye.
Thank you.
Bye.